Thank you all. In the course of preparing this report, we became aware of a number of abuses, not only as it related to the RF case, but also as it related to defendants generally across the board. And we felt it was important to call attention to these particular abuses and suggest recommendations that the Justice Department should employ to avoid these abuses, because the abuses themselves are very corrosive. They corrode the very substance of justice on which this country depends. And once that sense that the country is engaged in justice, once that sense that that commitment is no longer there, that the government is willing to allow injustices to occur, we are in much greater danger than we would be from any terrorist attack. And so I want to call attention to these things that we believe are great, serious injustices that are presently being carried out by the Justice Department. Perhaps the first, most important one is to focus on material support for terrorism laws and to make sure that these laws are never applied to people unless they advocate violence. There are many situations, many times, where people have been brought up on charges for doing things like contributing to a charity to relieve suffering, believing that they are trying to relieve suffering, or making free speech, or saying things like Muslims in foreign countries should have the right to defend themselves against invading foreign troops. These things have been held to represent material support for terrorism. And it is wrong. These are not people who are engaged in violence, and they should not be entrapped by laws that are being misrepresented or misread by the government. The entrapment defense needs to be strengthened. In the old days, we had a law in this country that the government should not be engaged in manufacturing crime. It makes sense. And yet, as a result of these cases, the terrorism cases, we have seen the entrapment defense eroded to the point where it is essentially meaningless now. And perhaps the worst example was in the Newburgh 4 case, where a person who the government relentlessly pursued to engage in terrorism and who finally said he wasn't interested in it and was then offered $250,000 if he would pursue it. And the government, it was held because of legal quirks and doctrines that they pushed forward, that that was okay. It was all right to offer somebody who was trying to withdraw from a plot $250,000 to go ahead. On the old standards, that would be entrapment. Today, it doesn't exist, and it should, because the government should not be in the business of manufacturing crime. A third suggestion that we made was to reform the Classified Procedure Act to provide that security-cleared counsel will always be notified and involved in any communications with the judge about evidence in the case. What we have seen over and over again in these cases is that the government will supply the judge with enormous amounts of secret material gathered through secret intelligence, and the defense counsel has been marginalized. You cannot argue against material that you don't know about, and so decisions are made by judges based on information that they have received from the prosecutor that the defense is unable to counter. And it is simply wrong. It is no proper way to run a justice system. And I know particularly in the RF case, on appeal, we filed our brief, they filed their brief, and they filed a secret brief with the Court of Appeals that we were not allowed to see. And then they filed a top secret brief that even the local prosecutor wasn't allowed to see. And then we all went down to the Second Circuit in New York and had an argument. And then we were excused, and the prosecutor went in and had a secret argument with the court. And the judgment of the court eventually reflected that kind of unlevel playing field, that imbalance, that kind of material that was secretly given to the court that we were not allowed to confront. Another recommendation that we made was that defendants should be immediately notified if any of the evidence in their case is derived from secret surveillance. This is absolutely essential, because otherwise you cannot challenge the evidence that comes in on the grounds that it was improperly obtained. But up until now, the government had not been doing it. Just as we were preparing this report, the government quietly said, actually, yeah, we're going to do that. We're going to start notifying defendants that information in the trial was derived from secret surveillance so they can challenge it. And this was the first time, really, that it would be possible for a defendant to challenge the secret surveillance that is going on all over the country now. Unfortunately, and the reason we included it in the report, we had a sense that the Justice Department was not really serious about this, that they might give notice in only 1 or 2 cases, whereas there are literally hundreds of these cases. Our F case was a classic example. We have still not received notice. And so we are putting this in there both to commend the Justice Department for taking this necessary step, but also to say we need more, much more sooner, we need more notification. Another recommendation was to stop prosecutions based on unrecorded interviews by the FBI. And I have to say that as this report was going to press, we got a quiet little announcement from the FBI that, yeah, actually, you're right, we're going to stop recording, we're going to start recording all of our interviews. Whether they knew about our report in advance, I don't know, I can't say. But whatever it is, they have announced that they're going to do it. I commend them for it, but once again, we want to make sure that they really stick to this and that this is something that they are serious about. The 8th one was we believe that it is absolutely necessary for the government to abolish the terrorism enhancement in sentencing. This is a special provision which is added in terrorism cases and essentially quadruples the sentence, so that a sentence in a normal case, which might be 10 years, might be 40 years. It is an enormous imposition to put on somebody, particularly when this person never intended to engage in violence. For example, made a contribution to a charity, was later found to contribute to material support for terrorism, and then their good intention of trying to relieve suffering is then receives a sentence quadruple what it would ordinarily have been. It's completely unfair, and the sentencing should be judged on the merits of the case, not on this artificial inflation because of the label that's put on it. And finally, we recommended that the government must reduce the use of solitary confinement and other punitive measures related to incarceration. Solitary confinement, of course, is a major issue all over the United States, and particularly here in New York State. But as it is used in these terrorism cases, it is particularly bad because it is often applied before the trial. Defendants, based on nothing more than a charge of material support for terrorism, are placed in solitary confinement, and some have stayed in solitary confinement for 5 or more years, waiting for trial, under conditions amounting to torture. And you can imagine how well a person could testify at trial or cooperate with their lawyer after 5.5 years in solitary confinement, as, for example, Mohammed Warsami was. This is a very serious problem that needs to be addressed, along with special administrative measures. And then, after sentencing, many of the terrorism defendants are placed in solitary confinement, again, based solely on the charges, not on the evidence that has come out at the trial that indicated they were in any particular danger. And they have, of course, created special, we call Muslim prisons, little Gitmos, or Gitmo North, out in the Midwest. There's 2 of them there, which is a largely Muslim population called communication management units. There's a lawsuit brought by Yassine Arif, among others, to close those down, and we believe that they should be closed down. But we don't think it should take a court to understand that essentially ethnic prisons have no place in American society. This is an absolute outrage. The government should close down those courts, regardless of what, close down those jails, regardless of what the courts say. So those are the recommendations that we make. We believe that these are serious matters that need to be addressed, not just because of the number of prisoners involved, there's several hundred prisoners involved in this, but because of what it is doing to our perception of justice and to the justice system in the United States itself. Thank you.